Hello, everybody. Bob Prince from Cervantes Chat and Prince. I am just taking the opportunity to provide some information related to a Supreme Court opinion from the United States Supreme Court today, June 15th, related to discrimination based off of sexual orientation, transgendered status, and homosexuality in general. The case is the Bostick versus Clayton County case. The opinion is written by Neil Gorsuch, and both him and Chief Justice Roberts joined the liberal wing of the Supreme Court to find that it is a violation of Title VII of the Civil Rights Act, which is looking at employment discrimination, to discriminate against somebody based off of their sexual orientation, and specifically their transgender status and their homosexuality. The case is involving three different cases that made its way through the courts of appeals. Two versions of the Court of Appeals said it was unlawful to discriminate against somebody or to terminate somebody based off of their statuses of homosexuality and transgendered. One circuit said that they believed that it was okay under the current law because the law had not been changed. The majority opinion basically states that because you have to talk about sex in being able to arrive at someone's homosexuality or transgendered status, that means you are making a decision based on sex, even though it's the first part of the question. And there is no specific thing in the federal law that addresses homosexuality or transgenderedness. However, the court is stating that because that first prong of the analysis, you have to decide what somebody's sex is supposed to be or is in order to make a decision based off of their homosexuality or transgendered status, that it is a decision based off of sex, which would be a violation of federal law to do. What does this have to do with condos and homeowners associations in Illinois? What it means is the Fair Housing Act, which has similar language that prohibits discrimination based off of sex, would have the same analysis likely, that if an association makes a decision based off of transgendered status or homosexuality, that decision would have an impact and potentially be liable, cause liability under this discrimination statute for the federal level. The state level, it actually is already illegal to discriminate against someone based off of their sexual orientation. But the Illinois Human Rights Act does also have the same because of sex language in it, which means since the state's law is interpreted very similar to the federal law, we would also expect a similar analysis. Thus, associations are clearly prohibited from discriminating against anybody based off of their sexual status, whether it's sexual orientation or their transgendered status. And basically, anytime you have to ask what somebody's sex is, you are going to be flirting with potential discrimination. It also can cause some concerns based off of HUD's guidance from a few years ago about hostile environments. If we become aware as an association that somebody is doing something based off of someone's sexual orientation, perhaps lodging complaints against them because of their status, because of sex, you as an association board have an obligation to prevent and stop that from happening. You have an obligation to take matters to prevent it from occurring in the future and to not help that person discriminate based off of sex. If you have any questions, feel free to contact our office. We'll be happy to try to assist. Other than, stay safe.